Senate will convene as a court of impeachment. The chaplain will lead us in prayer.
Let us pray. Sovereign God, author of liberty, we gather in this historic chamber for the solemn responsibility of these impeachment proceedings. Give wisdom to the distinguished Chief Justice John Roberts as he presides. Lord, you are all-powerful and know our thoughts before we form them. As our lawmakers have become jurors, remind them of your admonition in 1 Corinthians 10:31 that whatever they do should be done for your glory. Help them remember that patriots reside on both sides of the aisle, that words have consequences, and that how something is said can be as important as what is said. Give them a civility built upon integrity that brings consistency in their beliefs and actions. We pray in your powerful name. Amen.
Please join me in reciting the Pledge of Allegiance to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Would you please be seated? If there is no objection, the Journal of Proceedings of the trial are approved to date. No objection, so ordered. The Sergeant-at-Arms will make the proclamation.
Hear ye, hear ye, hear ye. All persons are commanded to keep silent on pain of imprisonment while the Senate of the United States is sitting for the trial of the articles of impeachment exhibited by the House of Representatives against Donald John Trump, President of the United States.
The Majority Leader is recognized.
Our colleagues, no motions were filed this morning, so we'll proceed to the House Manager's presentation. We will go for approximately 2 hours, then take a short recess when there is an appropriate break time between presenters.
Pursuant to the provisions of Senate Resolution 483, the managers for the House of Representatives have 24 hours to make the presentation of their case. The Senate will now hear you.
Mr. Chief Justice, Senators, Counsel for the President, and my fellow House managers, I want to begin by thanking you, Chief Justice, for a very long day, for the way you have presided over these proceedings. And I want to thank the senators also. We went well into the morning, as you know, until I believe around 2 in the morning. And you paid attention to every word and argument you heard from both sides in this impeachment trial, and I know we are both deeply grateful for that. It was an exhausting day for us, certainly, but we have adrenaline going through our veins, and for those that are required to sit and listen, it is a much more difficult task. And of course, we know our positions. You have the added difficulty of having to weigh the facts and the law. So I want to begin today by thanking you for the conduct of the proceedings yesterday and for inviting your patience as we go forward. We have some very long days yet to come. So let us begin. When a man, unprincipled in private life, desperate in his fortune, bold in his temper, possessed of considerable talents, having the advantage of military habits, despotic in his ordinary demeanor, known to have scoffed in private at the principles of liberty, when such a man is seen to mount the hobby horse of popularity, to join in the cry of danger to liberty, to take every opportunity of embarrassing the general government and bringing it under suspicion, to flatter and fall in with all the nonsense of the zealots of the day, it may justly be suspected that his object is to throw things into confusion, that he might ride the storm and direct the whirlwind. Those words were written by Alexander Hamilton in a letter to President George Washington at the height of the Panic of 1792, a financial credit crisis that shook our young nation. Hamilton was responding to sentiments relayed to Washington as he traveled the country that America, in the face of that crisis, might descend from a Republican form of government, plunging instead into that of monarchy. The framers of the Constitution worried then, as we worry today, that a leader might come to power not to carry out the will of the people that he was elected to represent, but to pursue his own interests. They feared that a president would subvert our democracy by abusing the awesome power of his office for his own personal or political gain. And so they devised a remedy as powerful as the evil it was meant to combat: impeachment. As centuries have passed, our founders have achieved an almost mythical character. We are aware of their flaws, certainly some very painful and pronounced indeed. And yet, when it came to the drafting of a new system of government never seen before and with no guarantee it would succeed, we cannot help but be in awe of their genius, their prescience even, vindicated time and time again. Still, and maybe because of their brilliance and the brilliance of their words, we find year after year it more difficult to imagine them as human beings. This is no less true of Alexander Hamilton, notwithstanding his recent return to celebrity. But they were human beings. They understood human frailties even as they exhibited them. They could appreciate, just as we can, how power can corrupt, and even as we struggle to understand how the framers might have responded to presidential misconduct of the kind and character that we are here to try, we should not imagine for one moment that they lacked basic common sense or refused to apply it ourselves. They knew what it was like to live under a despot, and they risked their lives to be free of it. They knew they were creating an enormously powerful executive, and they knew they needed to constrain it. They did not intend for the power of impeachment to be used frequently or over mere matters of policy, but they put it in the Constitution for a reason, for a man who would subvert the interests of the nation to pursue his own interests, for a man who would seek to perpetuate himself in office by inviting foreign interference and cheating in an election, for a man who would be disdainful of constitutional limit, ignoring or defeating the other branches of government and their co-equal powers, for a man who believed that the Constitution gave him the right to do anything he wanted and practiced in the art of deception, for a man who believed that he was above the law and beholden to no one, for a man, in short, who would be a king. We are here today in this hallowed chamber, undertaking this solemn action for only the third time in history because Donald J. Trump, the 45th President of the United States, has acted precisely as Hamilton and his contemporaries feared. President Trump solicited foreign interference in our democratic elections, abusing the power of his office to seek help from abroad to improve his re-election prospects at home. And when he was caught, he used the powers of that office to obstruct the investigation into his own misconduct. To implement this corrupt scheme, President Trump pressured the president of Ukraine to publicly announce investigations into two discredited allegations that would benefit President Trump's 2020 presidential campaign. When the Ukrainian president did not immediately assent, President Trump withheld two official acts to induce the Ukrainian leader to comply: a head of state meeting in the Oval Office and military funding. Both were of great consequence to Ukraine and to our national interest and security, but one looms largest. President Trump withheld hundreds of millions of dollars in military aid to a strategic partner at war with Russia to secure foreign help with his reelection. In other words, to cheat. In this way, the president used official state powers available only to him and unavailable to any political opponent to advantage himself in a democratic election. His scheme was undertaken for a simple but corrupt reason: to help him win re-election in 2020. But the effect of his scheme was to undermine our free and fair elections and to put our national security at risk. It was not even necessary that Ukraine undertake the political investigations the president was seeking. They merely had to announce them. This is significant, for President Trump had no interest in fighting corruption, as he would claim after he was caught. Rather, his interest was in furthering corruption by the announcement of investigations that were completely without merit. The first sham investigation that President Trump desired was into former Vice President Joe Biden, who had sought the removal of a corrupt Ukrainian prosecutor during the previous U.S. administration. The Vice President acted in accordance with U.S. official policy at the time and was supported unanimously by our European allies and key global financial institutions such as the International Monetary Fund that shared the concern over corruption. Despite this fact, in the course of this scheme, President Trump and his agents pressed the Ukrainian president to announce an investigation into the false claim that Vice President Biden wanted the corrupt prosecutor removed from power in order to stop an investigation into Burisma Holdings, a company on whose board Biden's son Hunter sat. This allegation is simply untrue, and it has been widely debunked by Ukrainian and American experts alike. That reality mattered not to President Trump. To him, the value in promoting a negative tale about former Vice President Biden, true or false, was its usefulness to his re-election campaign. It was a smear tactic against a political opponent that President Trump apparently feared. Remarkably, but predictably, Russia too has sought to support this effort to smear Mr. Biden, reportedly hacking into the Ukrainian energy company at the center of the president's disinformation campaign only last week. Russia almost certainly was looking for information related to the former vice president's son so that the Kremlin could also weaponize it against Mr. Biden, just like it did against Hillary Clinton in 2016 when Russia hacked and released emails from her presidential campaign. And President Trump has made it abundantly clear that he would like nothing more than to make use of such dirt against Mr. Biden, just as he made use of Secretary Clinton's hacked and released emails in his previous presidential campaign. Which brings us to the other sham investigation that President Trump demanded that the Ukrainian leader announce. This investigation was related to a debunked conspiracy theory alleging that Ukraine, not Russia, interfered in the 2016 presidential election. This narrative, propagated by the Russian intelligence services, contends that Ukraine sought to help Hillary Clinton and harm then-candidate Trump, and that a computer server providing this fiction is hidden somewhere in Ukraine. That is the so-called CrowdStrike conspiracy theory. This tale is also patently false, and remarkably, it is precisely the inverse of what the U.S. intelligence community's unanimous assessment was, that Russia interfered in the 2016 election in sweeping and systemic fashion in order to hurt Hillary Clinton and help Donald Trump. Nevertheless, the president evidently believed that a public announcement lending credence to these allegations by the Ukrainian president could assist his reelection by putting to rest any doubts Americans may have had over the legitimacy of his first election, even as he invited foreign interference in the next. To the degree that most Americans have followed the president's efforts to involve another foreign power in our election, they may be most familiar with his entreaty to the Ukrainian president on the now infamous July 25th call to do us a favor, though, and investigate Biden and the 2016 conspiracy theory. But that call was not the beginning of the story of the president's corrupt scheme, nor was it the end. Rather, it was merely part, although a significant part, of a months-long effort by President Trump and his allies and associates who applied significant and increasing pressure on Ukraine to announce these two politically motivated investigations. Key figures in the Trump administration were aware or directly involved or participated in the scheme. As we saw yesterday, one witness, a $1 million donor to the president's inaugural committee, put it this way: everyone was in the loop. After twice inviting Ukraine's new president to the White House without providing a specific date for the proposed visit, President Trump conditioned this coveted head of state meeting on the announcement of these sham investigations. For Ukraine's new and untested leader, an official meeting with the President of the United States in the Oval Office was critical. It would help bestow on him important domestic and international legitimacy as he sought to implement an ambitious anti-corruption platform. Actual and apparent support from the President of the United States would also strengthen his position as he sought to negotiate a peace agreement with Russia's President Vladimir Putin, seeking an end to Russia's illegal annexation and continued military occupation of parts of Ukraine. But most pernicious, President Trump conditioned hundreds of millions of dollars forces and their proxies, 15,000. And the military aid was for such essentials as sniper rifles, rocket-propelled grenade launchers, radar, night vision goggles, and other vital support for the war effort. Most critically, the military aid that we provide Ukraine helps to protect and advance American national security interests in the region and beyond. America has an abiding interest in stemming Russian expansionism and resisting any nation's efforts to remake the map of Europe by dint of military force, even as we have tens of thousands of troops stationed there. Moreover, as one witness put it during our impeachment inquiry, the United States aids Ukraine and her people so that we can fight Russia over there and we don't have to fight Russia here. Now, when the president's scheme was exposed and the House of Representatives properly performed its constitutional responsibility to investigate the matter, President Trump used the same unrivaled authority at his disposal as Commander-in-Chief to cover up his wrongdoing. In unprecedented fashion, the president ordered the entire executive branch of the United States of America to categorically refuse and completely obstruct the House's impeachment investigation. Such a wholesale obstruction of congressional impeachment has never before occurred in our democracy, and it represents one of the most blatant efforts at a cover-up in history. If not remedied by his conviction in the Senate and removal from office, President Trump's abuse of his office and obstruction of Congress will permanently alter the balance of power among the branches of government, inviting future presidents to operate as if they are also beyond the reach of accountability, congressional oversight, and the law. On the basis of this egregious misconduct, the House of Representatives returned 2 articles of impeachment against the president. First, charging that President Trump corruptly abused the powers of the presidency to solicit foreign interference in the upcoming presidential election for his personal political benefit. And second, that President Trump obstructed an impeachment inquiry into that abuse of power in order to cover up his misconduct. The House did not take this extraordinary step lightly. As we will discuss, impeachment exists for cases in which the conduct of the president rises beyond mere policy disputes to be decided otherwise and without urgency at the ballot box. Instead, we are here today to consider a much more grave matter, and that is an attempt to use the powers of the presidency to cheat in an election. For precisely this reason, the president's misconduct cannot be decided at the ballot box, for we cannot be assured that the vote will be fairly won. In corruptly using his office to gain a political advantage, in abusing the powers of that office in such a way to jeopardize our national security and the integrity of our elections, in obstructing the investigation into his own wrongdoing, the president has shown that he believes that he's above the law and scornful of constraint. As we saw yesterday on the screen, that under Article 2, he can do anything he wants. Moreover, given the seriousness of the conduct at issue and its persistence, this matter cannot and must not be decided by the courts, which, apart from the presence of the Chief Justice here today, are given no role in impeachments in either the House or the Senate. Being drawn into litigation taking many months or years to complete would provide the president with an opportunity to continue his misconduct. He would remain secure in the knowledge that he may tie up the Congress in the courts indefinitely, as he has with Don McGahn, rendering the impeachment power effectively meaningless. We also took this step with the knowledge that this was not the first time the president solicited foreign interference in our elections. In 2016, then-candidate Trump implored Russia to hack his opponent's email account, something that the Russian military agency did only hours later. Only hours later. When the president said, "Hey, Russia, if you're listening," they were listening. Only hours later, they hacked his opponent's campaign. And the president has made it clear this will also not be the last time, asking China only recently to join Ukraine in investigating his political opponent. Over the coming days, we will present to you and to the American people the extensive evidence collected during the House's impeachment inquiry into the president's abuse of power. Overwhelming evidence. Notwithstanding his unprecedented and wholesale obstruction of the investigation into that misconduct. You will hear and read testimony from courageous public servants who upheld their oath to the Constitution and their legal obligations to comply with congressional action despite a categorical order by President Trump not to cooperate with the impeachment inquiry. These are courageous Americans who were told by the President of the United States not to cooperate, not to appear, not to testify, but who had the sense of duty to do so. But more than that, you will hear from witnesses who have not yet testified, like John Bolton and Mick Mulvaney, Mr. Blair and Mr. Duffy. And if you can believe the President's words last month, you will also hear from Secretary Pompeo. You will hear their testimony at the same time as the American people. That is, if you allow it, if we have a fair trial. During our presentation, you will see documentary records, those the President was unable to suppress, that expose the President's scheme in detail. You will learn of further evidence that has been revealed in the days since the House voted to impeach President Trump, even as the President and his agents have persisted in their efforts to cover up their wrongdoing from Congress and the public. And you will see dozens of new documents providing new and critical evidence of the President's guilt that remain at this time in the President's hands and in the hands of the Department of Defense and the Department of State and the Office of Management and Budget, even the White House. You will see them, And so will the American people if you allow it. If, in the name of a fair trial, you will demand it. These are politically charged times. Tempers can run high, particularly where this president is concerned. But these are not unique times. Deep divisions and disagreements were hardly alien concepts to the framers. So they designed the impeachment power in such a way as to insulate it as best they could from the crush of partisan politics. The framers placed the question of removal before the United States Senate, a body able to rise above the fray, to soberly judge the president's conduct or misconduct for what it was, nothing more and nothing less. In Federalist 65, Hamilton wrote, "Where else than in the Senate could have been found a tribunal sufficiently dignified or sufficiently independent? What other body would be likely to feel confidence enough in its own situation to preserve, unawed and uninfluenced, the necessary impartiality between an individual accused and the representatives of the people, his accuser?" It is up to you to be the tribunal that Hamilton envisioned. It is up to you to show the American people and yourselves that his confidence and that of the other founders was rightly placed. The Constitution entrusts you to the responsibility of acting as impartial jurors, to hold a fair and thorough trial and to weigh the evidence before you, no matter what your party affiliation or your vote in the previous election or the next. Our duty is to the Constitution and to the rule of law. I recognize there will be times during the trial that you may long to return to the business of the Senate. The American people look forward to the same. But not before you decide what kind of democracy that you believe we ought to be, and what the American people have a right to expect in the conduct of their president. The House believes that an impartial juror, upon hearing the evidence that the managers will lay out in the coming days, will find that the Constitution demands the removal of Donald J. Trump from his office as President of the United States. But that will be for you to decide, with the weight of history upon you, and as President Kennedy once said, a good conscience your only sure reward. In drafting our Constitution, the framers designed a new and untested form of government. It would be based on free and fair elections to ensure that our political leaders would be chosen democratically and by citizens of our country alone. Having broken free from a king with unbridled authority who often placed his own interests above that of the people, the framers established a structure that would guarantee that the chief executive's power flowed only from his obligation to the people, rather than from a sovereign whose power was conferred on him by divine right. In this new architecture, no branch of government or individual would predominate over another. In this way, the founders ensured that their elected leaders and their president would use the powers of office only to undertake that which the people desired, and not for their personal aggrandizement or enrichment. What did those who rebelled and fought a revolution desire? No different than what we, the generations that have followed, desire. That no person, including and especially the president, would be above the law. Nothing could be more dangerous to a democracy than a commander-in-chief who believed that he could operate with impunity, free from accountability. Nothing, that is, except a Congress that is willing to let it be so. To ensure that no such threat could take root and subvert our fledgling democracy, the framers divided power among three co-equal branches of government: the executive, the legislative, and the judicial branches, so that ambition may be made to counter ambition. They provided for presidential elections every 4 years, and the framers required that the president swear an oath to faithfully execute the law and to preserve, protect, and defend the Constitution of the United States. Even with these guardrails in place, the framers understood that an individual could come to power who defied that solemn oath, who pursued his own interests rather than those of the country he led. For that reason, the framers adopted a tool used by the British Parliament to constrain its officials, the power of impeachment. Rather than a mechanism to overturn an election, impeachment would be a remedy of last resort. And unlike in England, the framers applied this ultimate check to the highest office in the land, to the President of the United States. Impeachment and removal of a duly elected president was not intended for policy disputes or poor administration of the state. Instead, the framers had in mind the most serious of offenses, those against the public itself. Hamilton explained that impeachment was not designed to cover only statutory or common law crimes, but instead crimes against the body politic. Hamilton wrote, "The subjects of its jurisdiction are those offenses which proceed from the misconduct of public men, or in other words, from the abuse or violation of some public trust. They are of a nature which may, with peculiar propriety, be denominated political, as they relate chiefly to injuries done immediately to society itself." In other words, impeachment would be confined to abuses of people's trust and to the society itself. This is precisely the abuse that has been undertaken by our current president when he withheld money and support for an ally at war to secure a political benefit. The punishment for those crimes would fit the political nature of the offense. As James Wilson, a delegate at the Constitutional Convention and a future Associate Justice of the Supreme Court, reasoned, impeachments are confined to political characters, to political crimes and misdemeanors, and to political punishments. That punishment, the framers determined, would be neither prison nor fines, but instead limited to removal from office and disqualification from holding future office. The framers chose to undertake impeachment for treason, bribery, or other high crimes and misdemeanors to underscore the requirement of an offense against society. In this phrase, high modifies both the crimes and the misdemeanors, in that both relate to a high injustice, a transgression committed against the people and to the public trust. The framers had two broad categories in mind: those actions that are facially permissible under the president's authority but are based on corrupt motives, such as seeking to obtain a personal benefit through public office, and those that far exceed the president's constitutional authority or violate the legal limits on that authority. In Article 1, we deal with the first evil, which the framers wished to guard against, that is, cases in which a president corruptly misused the power otherwise bestowed on him to secure a personal reward. Guarding against a president who undertakes official acts with the corrupt motive of helping himself is at the heart of the impeachment power. As one scholar explained, the president's duty to faithfully execute the law requires that he undertakes actions only when motivated in the public interest rather than in their private self-interest. Efforts to withhold official acts for personal gain countermand the president's sacred oath and therefore constitute impeachable behavior as it was conceived of by the framers. In Article 2, we also deal with a second evil contemplated by the founders, who made it clear that the president ought not operate beyond the limits placed on him by legislative and judicial branches. Impeachment was warranted for a president who usurped the power of the Constitution that was not granted to him, such as to defy Congress the right to determine the propriety, the scope, and the nature of an impeachment inquiry into his own misconduct. The framers fashioned a powerful chief executive, but not one beyond accountability of law. When a president wields power in ways that are inappropriate and seek to extinguish the rights of the Congress, he exceeds the power of his constitutional authority and violates the limits placed on his conduct. Obstruction of a separate and co-equal branch of government for the purposes of covering up an abuse of power not only implies a corrupt intent, but also demonstrates a remarkable antipathy towards the balance of power contemplated and enshrined in our Constitution. It is a betrayal of the President's sacred oath of office and of his duty to put the country before himself. On September 24th, 2019, Speaker of the House Nancy Pelosi announced that the House of Representatives would move forward with an official impeachment inquiry into President Donald J. Trump. The announcement followed public reporting in the United States and Ukraine that the President and his agents sought Ukraine's help in his re-election effort, and revelations that the White House was blocking from Congress an intelligence community whistleblower complaint possibly related to this grave offense. The next day, on September 25th, under extraordinary pressure, the White House released publicly the record of the July 25th call between President Trump and Ukrainian President Vladimir Zelensky. The call record revealed that President Trump explicitly requested that the new leader undertake investigations beneficial to President Trump's re-election campaign. Upon release of the record of the call, President Trump claimed that the call was perfect. Far from perfect, the call record revealed a president who used his high office to personally and directly press the leader of a foreign country to do his political dirty work. Asking for a favor, President Trump insisted that President Zelensky investigate a formidable potential political opponent, former Vice President Joe Biden, as well as the baseless conspiracy theory that Ukraine, not Russia, interfered in the 2016 election to assist then-candidate Trump's opponent. Witnesses who listened to the call as it transpired testified that they immediately recognized these requests did not represent official U.S. policy and instead were politically charged appeals not appropriate for a president to make. Key witnesses emphasized it was not necessary that Ukraine actually undertake the investigations, only that the Ukrainian president announce them. President Trump's objective was not to encourage a foreign government to investigate legitimate allegations of misconduct or wrongdoing abroad, made clear as well by the fact that the investigations he wanted announced have been discredited entirely. Rather, the president simply wanted to reap a political benefit by tarnishing a political rival and attempting to erase from history his previous election misconduct. To compel the Ukrainian president to do his political dirty work, President Trump withheld from President Zelensky two official acts of great importance: that coveted White House meeting, to which the President Zelensky had already been invited, and $391 million in military assistance Ukraine needed to fight the Russians. For a strategic partner of the United States in a hot war with Russian-backed forces inside its own borders, the symbolic support conferred on it by an Oval Office visit with the President of the United States and the life-saving support of our military aid was essential. As the House's presentation will make clear, in directly soliciting foreign interference and withholding those official acts in exchange for the announcement of political investigations beneficial to his re-election, the President put his own interests above the national interest. President Trump undermined the integrity of our free and fair elections by pressing a foreign power to influence our most sacred right as citizens, our right to freely choose our leaders. And he threatened our national security by withholding critical aid from a partner on the front lines of war with Russia, an aggressor that has threatened peace and stability on an entire continent. In so doing, the President sacrificed not only the security of our European allies, but also our nation's core national security interests. President Trump undertook this pressure campaign through hand-picked agents inside and outside of government who circumvented traditional policy channels. President Trump intentionally bypassed many U.S. government career officials with responsibility over Ukraine and advanced his scheme primarily through the effort of his personal attorney, Rudy Giuliani. President Trump carried out this scheme with the knowledge of senior administration officials, including the President's acting Chief of Staff, Mick Mulvaney, Secretary of State Mike Pompeo, Vice President Mike Pence, National Security Council Legal Advisor John Eisenberg, and White House Counsel Pat Cipollone. When the President became aware that the scheme would be uncovered, he undertook an unprecedented effort to obstruct the House of Representatives' impeachment inquiry and to hide it from the public and from Congress, including all evidence related to his misconduct. That cover-up continues today, as the administration has not provided a single document pursuant to lawful subpoenas by the House. Administration also continues to prevent witnesses from cooperating, further obstructing the House, efforts the President is no doubt proud of, but which threaten the integrity of this institution, of this Congress as a co-equal branch of power. Our ability not only to do oversight, but to hold a President who is unindictable accountable. But despite these efforts to obstruct our inquiry, the House of Representatives uncovered overwhelming evidence related to the President's misconduct through interviews with 17 witnesses who appeared before the Intelligence, Oversight and Reform, and Foreign Affairs committees. Many of these witnesses bravely defied White House orders not to comply with duly authorized congressional subpoenas. And were it not for them, were it not for Ambassador Marie Yovanovitch, who was the first through the breach, we may never have known of the President's scheme. I want you to imagine just for a minute what kind of courage that took. For Ambassador Yovanovitch, the subject of that vicious smear campaign, to risk her reputation and her career to stand up to the President of the United States, who's instructing her through his agents, you will not cooperate. You will not testify. You will tell them nothing. Or Bill Taylor, West Point graduate, Vietnam veteran, with a Bronze Star, and something he was even more proud of, the Combat Infantryman's Badge. He knows what courage is. He showed a different kind of courage in Vietnam, but he also showed courage, as did others, in coming forward, in defying the President's order that he obstruct, to tell the American people what he knew. But for the courage of people like this, and Lieutenant Colonel Vindman, a Purple Heart recipient, but for their courage, we would have known nothing of the President's misconduct. Nothing. When the President directs his ire towards these people, this is why. Because they showed the courage to come forward. Now, we held in the Intelligence Committee 7 open hearings with 12 fact witnesses. Separately, the Judiciary Committee held public hearings with constitutional law experts and counsel from the House Intelligence Committee as it sought to determine whether to draft and consider articles of impeachment. The House also collected text messages related to the President's scheme from a witness who provided limited personal communications. Since the conclusion of our inquiry, new evidence has continued to come to light through court-ordered releases of administration documents and public reporting, underscoring that there is significantly more evidence of the President's guilt, which he continues to block from Congress, including the Senate. Nevertheless, the documents and testimony that we were able to collect paints an overwhelming and damning picture of the President's efforts to use the powers of his office to corruptly solicit foreign help in his reelection campaign and withhold official acts and military aid to compel that support. Over the coming days, you will hear remarkably consistent evidence of President Trump's corrupt scheme and cover-up. When you focus on the evidence uncovered during the investigation, you will appreciate there is no serious dispute about the facts underlying the president's conduct. And this is why you will hear the president's lawyers make the astounding claim that you can't impeach a president for abusing the powers of his office, because they can't seriously contest that that is exactly what he did. And so they must go find a lawyer somewhere. Apparently, they could not go to their own attorney general, who was just reported in a memo he wrote as part of the audition for attorney general, which opined that a president can be impeached for abusing the public trust. Couldn't go to Bill Barr for that opinion. Couldn't go to even Jonathan Turley, their expert in the House, for that opinion. No, they had to go outside of these experts, outside of the constitutional law, to a criminal defense lawyer and professor. And why? Because they can't contest the facts. The president was the key player in the scheme. Everyone was in the loop. He directed the actions of his team. He personally asked a foreign government to investigate his opponent. These facts are not in dispute. Ultimately, the question for you is whether the president's undisputed actions require the removal of the 45th president of the United States from office, because he abused his office and the public trust by using his power for personal gain, by seeking illicit foreign assistance in his reelection and covering it up. Other than voting on whether to send our men and women to war, there is, I think, no greater responsibility before you than the one before you now. The oath that you've taken to impartially weigh the facts and evidence requires serious and objective consideration. Decisions that are about country, not party, about the Constitution, not politics, about what is right and what is wrong. After you consider the evidence and weigh your oath to render a fair and impartial verdict, I suggest to you today the only conclusion consistent with the facts and law, not just the law but the Constitution, is clear, as described by a constitutional law expert's testimony before the House. If this conduct is not impeachable, then nothing is. Let me take a moment to describe to you how we intend to present the case over the coming days. Today, you will hear the details of the president's corrupt scheme in narrative form, illustrating the timeline of the effort through the testimony of numerous witnesses who came before the House, as well as the documents and materials we collected as evidence during the investigation. After you hear the factual chronology, we will then discuss the constitutional framework of impeachment as it was envisioned by the founders, before we analyze how the facts of the president's misconduct and cover-up lead to the conclusion that the president undertook the sort of corrupt course of conduct that impeachment was intended to remedy. Let me start with a preview of the president's scheme, the details of which you'll hear during the course of this day. President Trump's months-long scheme to extract help in his 2020 re-election campaign from the new Ukrainian president involved an effort to solicit and then compel the new leader to announce political investigations. The announcement would reference to February 2017, less than a month after the U.S. intelligence community released its assessment that Russia alone was responsible for a covert influence campaign designed to help President Trump win the 2016 election. President Putin said,